Hello. Hello, all my students. Our lecture today is still on the topic of electronic transactions laws in this country, okay, in Thailand. So from our previous lecture, we have discussed a lot of things, okay, which are indeed contained in the specific law in this country, or if you can remember, it is known as the ETA or the Electronic Transactions Act, okay, 2001. Okay, I have discussed a lot of principles in this act. We have seen that this act has been modeled after the model law on e-commerce, the Astro model law on e-commerce, and also the Astro model law on electronic signature. We have discussed the requirement as to drawing chain, okay, and we have also discussed the requirement as to signature. Okay, so with respect to the signature, okay, we are going to discuss this, okay, in furtherance of our lecture last week. Remember when we talk about, the requirement as to signature, we have seen that many transactions, many contracts are required by law to be signed. Okay, so now, when we switch from many documents into e-documents, we have seen that, when we now to use e-documents, we cannot just enter signatures in the form of a normal handwritten signature, but we can use an electronic signatures. So our ETA, our Electronic Transactions Act, allows us to use an e-signature as well. We have seen the requirement as to signature as contained in the Article 7 of the model law on e-commerce. Okay, so if you can remember well, okay, there are two requirements. In order for your e-signature to be recognized by law as a valid signature, you have to go through these two requirements. The first one is that your signature must be created by a method which is what? Which is able to identify the person, identify you as the signatory, and also it must be able to indicate the that person's approval of the information contained in that data message. Okay, we switch from paper into e-documents so that we can't sign on a piece of paper, but we can affix our e-signature, okay, with e-documents. Okay, so if we switch from paper into e-documents and we would like to use an e-signature in place of a handwritten signature, we have to use a method which is able to identify ourselves, and it has to also be able to show or to indicate that we have approved the information contained in that e-document. Okay, so this is the requirement number one. And in the requirement number two, okay, which is contained in Article 7, B in the model law on e-commerce. Okay, so in the requirement number two, it is that the requirement which you are used for creating your e-signature must be as reliable as was appropriate for the purpose for which the data message was generated or communicated. Okay, having regard to all the circumstances. Okay, so this is requirement of, this is the so-called the requirement of reliability. So two requirements in order for an e-signature to be equivalent to a handwritten signature: the requirement of identification and the requirement of reliability. Okay, with respect to the first requirement, the one that you have to use a method which is able to identify yourself and to indicate that you have approved the information contained in your data message. This is known as the requirement as to identification or authentication. Okay, and the requirement number B here, the requirements contained in Article 7b, it is the requirement as to reliability. Remember, there are so many methods for the creation of signature. The model law does not tell you to use any particular method, provided that, okay, all methods are welcome to be used, provided that they must be they must fulfill the requirement as to identification and the requirement as to reliability. Okay, so that if you can remember, I have shown you, okay, all these methods. the iris, the voice print, palm or fingerprints, okay? And we have seen that from Article 7 of the Australian law on e-commerce, okay, into what is in our ETA. Thailand's ETA has taken the concepts from Article 7 of the Australian law on e-commerce. So we have seen that the provision of Article 9 in our Electronic Transactions Act, okay, replicates what we have seen in Article 7 of the model law on e-commerce. Okay, if you look at Section 9 of our ETA, you can see these two requirements. Okay, according to Section 9, in the case where a person is to enter a signature in any writing, it shall be deemed that it's data message bears a signature. That means that when the law requires you to enter a signature, you are welcome, okay, to use an e-signature, provided that you comply with the requirements number 1 and the requirement number 2 here. Okay, so if you look at the requirement number 1, that is the requirement as to identification or authentication, okay, in the same way as what we have seen in Article 7 of the Australian model law on e-commerce. And if we look at the requirement number 2 here, which is contained in Section 9, subsection 2 here, okay, we can see that this simply replicates the requirement of reliability as contained in Article 7 B of the model law on e-commerce. Okay, this is what we have seen from our last lecture. Okay, and now what I'm going to tell you. Okay, if we compare the two versions, okay, the version in the model law on e-commerce and the version in Section 9 of our ETA, okay, we can see the similarities here. But what I'm going to tell you is this: after the ASITRO has put forth the model law e-commerce, including Section 7, okay, which allows the use of e-signatures in place of normal signatures, okay, ASITRO has also put forth two refinements. The refinements are made on 2 points. Okay, we have seen that there are 2 requirements. Requirements number 1 and requirement number 2. Remember, the requirement number 1 is the requirement with regard to the identification or authentication. The requirement number 2 is the requirement as regards reliability. Now, the UN has put forth the refinement with respect to these 2 requirements. The refinements with respect to 2 requirements. Okay, we will look at these 2 refinements, okay, on 2 points, okay, in this lecture. These refinements are reflected in the UN Convention on the Use of Electronic Communications in International Contracts 2005. Now, what are the 2 aspects of refinements? The first refinement it is the refinement with respect to the identification requirement. The second refinement, it is the refinement which is in relation to the reliability requirement. Okay, look at the first one. Remember, if we get back to the first requirement, I'm going to get back to the first requirement here. The requirement of identification or authentication. Okay, if you look at Section 7 again, if you look at Section 7 of the model law on e-signature, we can see that, okay, the identification requirement or the authentication requirements, okay, requires us to do what? To use a method which is capable of identifying the signatory and indicating that the signatory has approved, okay, the content of the message which is being signed, okay. So the keyword here, it is the approval with respect to the requirement of identification, the method which is used for creating any signature must be able to, to identify the signatory, and must be able also to indicate that the signatory has approved, the information contained in the data message. Okay, it has later been felt by the United Nations that in many contexts, when people use an electronic signatures, they do not use it. They do not use it for showing that they have approved, the content of the data message. Okay, if you look at the example, okay, we may look at the situation in which a person, okay, sign his own name as a witness. When you are requested by anyone to just, sign a document as a witness, do you approve the document? No, you do not approve that document. You just sign as a witness, but you do not approve the document. You don't approve any content in that document. Okay, so the UN subsequently, the UN came to the proper understanding that in many contexts, a person signs his or her own name not for approving anything, but for something else. Okay, they do not sign their names to approve the content of the document. Okay, but they sign their names in order to indicate their intention with respect to with respect to something. Okay, when a witness signs a document, the witness does not approve the document, but the witness just indicate his intention in respect of the transaction in question. Okay, that is why when the UN, okay, came to this realization, okay, the UN in the Convention of 2005, the UN has changed the word approval into something else. Okay, if we look at the new version, okay, from the old version into the new version, when I say the old version, that is Article 7 of the Model Law on Commerce 1996, right? Remember, when we see the word approval, a method is used to identify that person and to indicate that person's approval of the information contained in the message. Now, from this old version into this new version, the new version, it is the one in the UN Convention on the use of electronic communications in international contracts. Look at the wording here. The wording in Article 9.3a. Article 9.3a of the UN Convention, okay, provides as follows. A method is used, okay, a method is used to identify the parties and to indicate that party's intention in respect of the information contained in the e-communication. Okay, that means that, okay, there is a change from the word approval into the word intention in respect of the information. Okay, that is the way to confirm that in many contexts, okay, a person, okay, enter his signature not to indicate his approval of any content, but that he does so to just indicate his intention in respect of, the transaction in question. Okay, so if we look at the new version, which is in Article 9.3a, we will see the change from the word approval into the intention. Okay, intention, that is to make sure that, okay, this new version respond to the truth with respect to making transactions in our lives. Okay, So now, that is the first requirement. The requirement in what? The requirement, the requirement with respect to the identification requirement. Now coming to the second refinement. The second refinement, it is refinement in the reliability requirement. Okay, now for the on this point, okay, we can have a look at that. Okay, we can have a look at, if we get back to what is in the, section 7, sorry, article 7. If we go back to article 7 of the model law on e-commerce 1996, okay, we will see, remember, there are two requirements. The first one in 7A, the second one in 7B. Now, we are talking about, the requirement number 2. The requirement number 2 in article 7B, that is the requirement of reliability. In order for an e-signature to be equivalent to a normal signature, it must be created by a method which is what? Which is reliable. And we have seen already that, in order to consider the reliability, we have to look at all circumstances of the case. Remember, okay? Now, on this point, the UN has come to, the realization that sometimes, sometimes it happens as well that when a person creates a signature, okay, when a person creates a signature, that person may create a signature using a method which is not reliable. Even though that method is not reliable, but the thing is that both parties, they have duly accepted that signature. They have no problem. Okay, so far they have had no problem. They have gone ahead with that transaction. Let's say that company A and company B, they have entered into a contract. Let's say that contract, it is a contract of sale. A contract of sale of what? Let's say of a submarine, okay? A contract of sale of a submarine, which is worth something like, the 20 let's say that the value of this submarine is what? $1,000 million. The value is too great. But the parties, company A and company B, they have used electronic signatures which are created by a very, very simple way. Okay, they may just have their e-document. They may have just a contract which is typed using the Microsoft Word, and they just sign the document this way. They may just sign this, the Word document by affixing the signature which has been created by scanning, the handwritten signature into the image file, and then they just attach that image file, the signature image file, okay, to the Word document, okay. That method is so simple. So if we look at, the requirement as to reliability, we cannot say that is the e-signature which fulfills the reliability requirement, because it has been created by what? By a method which is not reliable at all. The value of this transaction is too great. Okay, a submarine which is worth $1,000 million, but this contract has been signed by a method which is so simple, so that it is, in this case, the signature in question, it is an e-signature which is created by a method which is not reliable. But party A, company A and company B, they have had no problems. They have gone ahead with this contract. They have performed some obligations. Now, on a good day, let's suppose that on a good day, the seller does not want to be bound by this contract anymore. So that the seller will come up with this argument. The seller say, well, buyer, sorry for you. The seller think that now this contract is not enforceable because it has not been signed. Even though it bears the e-signature, but the e-signature which we use are created by a method which are not reliable, so that we cannot say that this contract has been duly signed. And the e-signature which is used, okay, between us, it is not a valid signature because it has been created by a method which is unreliable. So, if the sellers argue this way, will that be fair? It will not be fair, and in fact, it also runs counter to good faith. Because at the beginning, the two parties, they have accepted the signature as valid. See, so there is no point allowing them to just argue now that the signature is not valid anymore, simply because it has been created by a method which is not reliable. It is against good faith and to allow the parties to say so. Okay, so that is why if we face the situation like this, okay, even though the signature which is used is created by a method which is not reliable, but the parties have at the beginning, they have since the beginning, okay, from the very beginning, okay, they have had no argument, they have had no objection, okay, they have in fact accepted as valid. So in this case, the law just, when the law comes to realize this, the law now, okay, switch to the new position. Remember, look at the old position. Remember, the old position is that the method which is used for creating the signature must be reliable. But the new version say that, well, we give you two choices, choice 1 and choice 2. Okay, the law treats an e-signature as valid when it is proven 1 or 2. Okay, 1 or 2. Right. If you look at this one is what this one is the old version. Sorry, I just mixed up. If you look at the old version, which is reflected in Article 7B of the model law on e-commerce, remember the old version requires that. Okay, a method. The old versions require that the method is what? The method is reliable. Okay, the method be reliable, but the new version gives you choices. Okay, the method which is used for creating signature must be either 1 or 2. Either 1 or 2. See, let's be that. You now have two choices. The method which you use for the creation of your signature must be 1 or 2, either 1 or 2. What is the number 1 here? The number 1 is the same. The number 1, it is the requirement of reliability. Okay, the method used is either as reliable. Okay, reliable as appropriate for the purpose for which the electronic communication was generated or communicated in the light of all the circumstances, including any relevant agreement. So this is the same thing as what we have seen in what? In Article 7B of the model law on e-commerce. See, but in the UN Convention, okay, in the new version, embodied in Article 9.3b of the UN Convention on the use of electronic communications in international contracts, the convention gives choices. Okay, the method must be either either reliable. Okay, this first choice, it is the same thing as the old version. But what is in the second choice here? The second choice is or proven in fact to have fulfilled the functions described in subparagraph A above. Subparagraph A, it is the subparagraph which says something about the identification requirement. Okay, so that means that in the second choice here, even though the method which you use for the creation of signature is not reliable, so that you cannot fulfill, the requirement in A here, but even though it is not reliable, it can just fulfill the identification requirement. It can just identify the signatory, and it can just indicate the signatory's intention, okay, with respect to the information. Okay, so even though it's not reliable, it doesn't matter. If it can just perform the identification function, then fine. Okay, now you have to understand this very well. Okay, at first sight, you may just think that Article 9.3b, the new version, of course, okay, allows you two choices at your own election. Okay, you may choose one or two, but the thing is that you may just choose number two only when only when there are some facts that the two party A, party B, they have gone ahead with the signature. They have used the signatures which are not reliable. They have used the signatures which are created by a method which is not reliable, but they have had no objection. Okay, they have had no objection. They have raised, the no challenge at the beginning. At the beginning, they have just accepted the signature as valid. If we have the situation like this, if the circumstances of the case are like this, then you may forego the requirement of reliability, and you can just come to the second. You can just come to the second choice. Okay, that is the method which you use for creating your signature, even though it is not reliable, but it can just perform the identification function. Then that is enough. Okay, again, you can just just opt for the choice number 2 here only when there are circumstances that the party A and party B, they have gone ahead with the transaction. They have had no arguments. They have had no objections with respect to signature in the first place. So if the facts are like this, then the law just stops the party from making any argument that, well, the signature is not valid. The signature is not a valid one because it has been created by a method which is not reliable. No, the law does not want you to argue this way anymore. If you do so, you just go against the requirement of good faith. Right. So again, if there are no facts, if there are no circumstances this way, circumstances which indicate the two parties, okay, going ahead with the transaction, and subsequently just argue that the signature is not valid, then you will have to limit yourself to the choice number 1. Right. It doesn't mean that choice number 2 here can be just the use at your own election. Okay. The choice number 2 here will be call into play only when there are circumstances which I have explained to you only. Okay. That is something which have to be made clear. Okay. So if you want to have a read of the full wordings, okay, of the new version, okay, you can just go ahead and have a look at Article 9.3. Article 9.3 say where the law requires that a communication or a contract should be signed by a party or provides consequences for the absence of a signature. That requirement is met in relation to an e-communication. If A and B, a method is used to identify the party and to indicate that party's intention. See, the word intention, it is used in place of the word approval. Okay, a method is used to identify the parties and to indicate the party's intention in respect of the information contained in the electronic communication. Okay, and B, the method used is either 1 or 2. Okay, 1, as reliable as appropriate for the purpose for which the communication was generated or communicated in the light of all the services, including any relevant agreement. Okay, or 2, proven in fact to have fulfilled the functions described in subparagraph A above by itself or together with further evidence. Now, what is in Thai law? Remember, a while ago I just showed you, the wording of the Thai ETA in Article 9. This is Article 9 before amendment in 2019. Right. Now, from the version before the amendment in 2019 into a version after the amendment in 2019. So this is the version, okay, after the amendment in 2019. See, you can see that 69 has now been amended to be like this, okay. We have the amendment in number 1 and number 2, and the requirement in number 2 is split into 2A or 2B. See, so this is in the same way as what we have seen in Article 9.3, Article 9.3, okay, B1 and B2 of the UN Convention. Okay, UN Convention on the use of e-communications in international contracts 2005. I don't need to just give you more explanation, okay, of this, because it's just mimic the Thai section 9 here, just mimic Article 9, 3, okay, B, 1 and 2, okay, of the UN Convention. So that my explanation, of, the UN Convention, okay, Article 9, 3, B, 1 and 2 here of the UN Convention will also apply to, the Thai version as well. The Thai counterpart is Section 9 of the ETA, okay. Or if you want to look at, the Thai language, then you can have a look. You can have a look at the ETA in the Thai version as well. Okay. Now what we will see here is something which is known as a digital signature. Digital signature. What is it? Okay. A digital signature. It is indeed one form of electronic signatures. Okay. It is an electronic signature which is created by a technique or technology which is known as the PKI technology, public key infrastructure. PKI for public key infrastructure. Okay, the PKI technology, it is a technology which is based upon the key pair. Okay, there must be a key pair, two keys. Okay, two keys, the private key and the public key. Okay, a private key and a public key. I'm going to show you, okay, how this kind of signature works. If we have the infographic, okay, to explain how this signature works, we will have something like this. Okay, let's suppose that I now have an email message. Okay, I have a message, a data message. I hope that you remember the word a data message. Okay, the model law uses the word data message, but in the UN Convention, okay, UN Convention on the use of electronic communication in international contract, the convention does not use the word a data message, but it uses the word an electronic communication. Okay, so the word electronic communication in the UN Convention, it is equivalent to the word data message. Okay, in the model law on e-commerce or the model law on electronic signatures. Okay, so now back to this infographic. Okay, let's suppose that I now have an email message. I would like to affix, okay, a digital signature, okay, to this email message. What the computer will do for me is this: the computer will just put this message into the hash function. Okay, so after the hash function, we will get something like this, which is known as a message digest. This is something you heard like this, okay? Something unreadable, something unintelligible. Okay, this is not yet a signature. In order for us to have an a signature or a digital signature, okay, we will have to go through one more process, okay, the process of encryption, okay. So in the process of encryption, we need to have this key, which is known as the private key, okay, which is called a code, a code given by computer, a code, ascribed by a computer. Okay, so we will use this private key in order to encrypt the message. Okay, remember from the message, the message is put into the hash function in order for us to have a message digest. Okay, and this message digest will have to be encrypted by this private key. After the encryption, okay, we will have this. After this message digest is encrypted, we will have this digital signature, okay, and it is this digital signature which is going to be affixed to the original message, so that if we go back to this one, we have a message. Let's say that the message is an order. This message is an order, or an order for the 10 books. I now send an order in order to mean for 10 books. I ordered 10 books, let's say from a bookstore. Okay, and then my email message is hashed. When it is hashed, it will become a message digest, and this message digest is encrypted by this private key. And after the encryption, okay, we will have a digital signature, and this is going to be affixed to the original message, i.e. an order for 10 books. So now my email, okay, by which I place an order for 10 books, okay, is affixed with this digital signature. So in a way, my order is now digitally signed. Okay, so when my message is sent to the bookseller or the bookstore, okay, the bookstore will see that, okay, my message is signed. My message is affixed with a digital signature. Okay, so that the computer at the side of the recipient will do this. Okay, it will do the same thing as what has happened at the sender side. At the sender side, the message is hashed. So at the recipient side, the message is going to be hashed back. It is going to be put into the hash function as well. Okay, so that we will have the hash result after the message is put into the hash function. Okay, we can see that the hash result at the recipient side is the same as the hash result at the sender side. Okay, so that in this case we can presume that the message as sent by, let's say, by A, this is A, and the other side is B. Okay, the message as sent by A to B, it is authentic. Okay, it is not changed by anyone. Okay, so in order to have greater, in order to have greater security, we will do one more thing. Okay, at the sender side, we can see that the sender uses what? Use the private key to encrypt the message. At the recipient side, the recipient on the message will use also the key, but not the same key as the sender side. Okay, but the key known as the public key. Okay, but this public key, has some mathematical association with the private key. Okay, so that when the recipient uses the public key to do the decryption, okay, not encryption. Encryption occurs at the sender side. Okay, the decryption occurs at the recipient side. Okay, so when the recipient of the message, when B uses this public key to decrypt the message, we can see that we will have the result here. If all the results at the recipient side, okay, are identical with the result or to the result of the sender side, then that means that this message, i.e. in this case, an order for 10 books, is authentic. It has not been changed by anyone. It has not been altered by anyone, in the course of its transmission, okay, to the recipient, okay. And we can see that the signature which is affixed to this message, okay, it is authentic, okay. If all the results at the recipient side are identical to the result at the sender side, that means that, okay, the message and the signature, okay, they are what? They are authentic, okay. There has been no variation, there has been no alteration by anyone in the course of the message transmission, okay. So this is what is going on when a person uses the so-called digital signature, okay. So let's have a look at what happens if the data is altered, or we use the word compromise, okay. If the data is compromised, what is going to be the result? Again, if we go to the infographic, okay, we have now an order sent by A, an order placed by A for 10 books, and then the computer will just put this message into the hash function, okay, so that we have now the message digest, and that message digest is encrypted by this private key, right? And after that, after the encryption, then we will have the digital signature, which is going to be affixed to the original message. When the original message, i.e. an order for the books, okay, is sent to the seller, okay, the computer at the seller side will just do the verification. Let's suppose that in the process of transmission, somebody just has added 0 here, okay, in order to turn the order for 10 books into an order for 100 books, okay, like this. When the computer at the seller side just put the message back into the hash function, we will see that simply because the message as received has been changed, so the message is not the same as the one at the sender side anymore, okay. So that when this message as altered is hashed, then we will get what we will get here should not be the same as the result at the sender side, okay. So we can see that the hash result at the recipient side, okay, is similarly different, okay, from that at the sender side, okay. So in this case, okay, we can see that when at least one value, okay, one hash result or hash value is not the same as the one on the sender side, then the computer at the recipient side, in this case the computer at the sender side, will just tell that, well, it seems that the message is sent by A to B has been altered. In this case, if you are B, you will just forget about this order. You will not do anything in response to this order, simply because you know that this message as sent by A has been altered by a third person, okay. It has been altered by an unauthorized person, okay. So in this case, B, the seller will just choose not to proceed with this order as received by A, okay. So again, this picture also gives you a very good explanation, okay, of what's going on, okay, when the people uses this kind of signature, i.e. a digital signature. If you look at this picture, okay, we have A and B. A does have this message, and if A wants to digitally sign this message, A will just put this message into the hash function, okay, so that we have hash value here. And after this message is hashed, then the A will use this private key to encrypt the message. After the encryption, okay, A will have a signature. So the signature, it is attached or is it affixed with this message. So when it is sent to B will do the verification, okay? The data will be hashed back, and if the hash value is identical to the hash value at the sender side, okay, that means that, okay, the message is sent by A is authentic, and for greater security, B will also use the public key to decrypt the message, okay? If the hash value which is going to be obtained is identical to the one at the sender side, that means that this data which is signed digitally, okay, it is authentic. It has not been altered by anyone. Okay, you may wonder, well, that if we get back to this picture, you may wonder how can we get this public key? A uses the private key to do the encryption file, but when B wants to verify, the message as received from A, how can B get this public key? Well, the answer is well, B will not just request this public key from A. In this case, okay, usually when persons use this kind of signature, people will use the service of the CSP. CSP, it is the certification service provider. The CSP, it is a trusted third party. Okay, in order for A to gain credibility, okay, A usually will subscribe to the service provided by the CSP. The law does not indeed. Okay, if we look at this picture again, with the one in place. I think that I just show you this picture. Okay, the law does not compel anyone to use services of the CSP. Okay, the law does not force anyone to subscribe to the services of the CSP. But if you use this kind of signature and you do not subscribe to the certification services offered by the CSP, then nobody will trust you. Okay, because if you just send the other key to the recipient, that means that, well, you get the control of both keys. Okay, normally people will subscribe to the CSP services, and the CSP, sometimes we call the CSP as CA for the certification authority. Okay, so the CSP will just provide the software. If A, let's say this is A, okay, the sender is A, and the recipient is B. Okay, if A sends a message to B, and A uses a digital signature, A will normally use the service of the CSP. The CSP will just give the software to A in order to A to generate this key, the private key. So this private key, it is generated by the software provided by the CSP. When when A uses this private key to encrypt the message, in order to get the signature like this, the program, the software will automatically put the public key in this message, so that the message which is signed digitally and which is going to be sent to B also contain the public key automatically. So when B, as the recipient of this message, would like to do the verification, B's computer will just get this public key to verify this message as sent by A automatically. Okay, so that the person who on this public key, it is not A, but it is the CSP. Okay, it's the CSP whose service is subscribed to by A. Okay, so in this case, when there is the trusted third party, then the recipients of messages will have confidence in this kind of verification. Okay, so in the practice, okay, that normally the big companies, when they use e-signatures like this, when they use digital signatures, they do use the services of the CSP. So when CSP services are involved, you will see that there are indeed three persons. The first one, it is the one who sign. We call this one signatory or signature holder. Okay. The second one, it is the CSP or the CA. Right. The third one is the one who receives the message, which is digitally signed. This one is referred to in the law as the relying party. Okay. Relying party means that any party who receives the messages which are signed by this kind of signature, which are signed by what? By a digital signature. Okay. So there are these three persons again. The law does not compare anyone to use the CSP services, but as a matter of practice, okay, if you are, if you do business and if you would like your business to be trusted by, by the parties who receive your messages which are signed by your signature, you should subscribe to the services of the CSP. Okay, otherwise you will not be you will not be trusted by trade partners or the customers. Okay, so why do we talk about this kind of signature? Why do we talk about the digital signatures? I'm going to tell you this minute, but now let me just have a check on what is on the screen on my mobile phone. Okay, to make sure that nothing undesirable happens. Okay, in the course of my lecture. I have to make sure that the video signal and audio signals are okay, without any technical problems. Okay, so far so good. Okay, nobody just send messages to inform me about any technical problems. Okay, so fine. Let me just continue the lecture at the moment. Okay, now I need to just turn on the air conditioner as well. Okay. Because the weather seems to, the temperature in the room seems to be a little bit high. Okay, so just now I just switched off the air conditioner because I feel something rather cold. But now I think that the temperature seems to be high again. Okay, so now back to the lecture here. Remember, you may wonder why I need to spend quite a lot of time. Okay, talking about the signature which is known as digital signature. Okay, the reason why I talk about digital signatures is this. Okay, of course, the law does not compel anyone to use any particular method for the creation of signature. You're welcome to use any method. You're welcome to use any technology for the purpose of creating the signature. Okay, provided that you comply with, or provided that you fulfill the requirements number 1 and number 2. Remember the requirement of what? The requirement of identification and the requirement of reliability. Okay, so if you can prove that your method which is used for creating signature is reliable, then fine. You will have to prove the reliability of the method. Okay, but it has been, it has been recognized that there are some methods for the creation of electronic signatures which are regarded by the industry as very, very reliable. Okay, certain methods which are used for creating signatures, okay, are recognized in the industry as highly secure and reliable, so that the law, okay, seems to have a response to this actuality. Given that in the industry, some methods which are used for creating signatures are regarded as highly secure and reliable, so the law, okay, gives the presumption of reliability if you use the signatures which are of the description, okay, as required by law. If you use this kind of methods, the methods which possess some features, then the law will treat that the signatures which is created by that method is reliable without you having to prove the reliability. So in a way, you are what? You're given what by law? You are given the legal presumption of reliability. You don't need to prove that your signature is created by a method which is reliable. The law will presume that that method is reliable and your signature will be reliable accordingly. Okay, so in a way you will have you will have the benefit of presumption, the benefit of a presumption of reliability by law. Okay, so this legal presumption of reliability is embodied in the Article 6.3 of the Astro Model Law on Electronic Signatures, okay, 2001. Okay, if you look at the provision of Article 6.3, okay, the 6.3 of the Model Law on Electronic Signatures 2001, you will see this wording. Okay, and electronic signature is considered to be reliable if 1, 2, 3, and 4. That means what? That means that if you want to have an electronic signature and your e-signature is created by a method which is of these features, the features explained in 1, 2, 3, 4 here, then the law will treat that signature as reliable without you having to prove. So in this way, you will have the benefit of the legal presumption of reliability. Now, and let's have a look at the feature in 1, 2, 3, 4 here. 1, look at number 1 here. The signature creation data are within the context in which they are used, linked to the signatory and to no other person. Okay, and 2, the signature creation data were at the time of signing under the control of the signatory and of no other person. So the feature in number 1 and number 2 here are important. Okay, in fact, if the requirement in number 1 and 2 here, if the features in 1 and 2 here are fulfilled, then the features in 3 and 4 will normally follow automatically. In some countries, the ETA law just make a mention of the requirement in the feature in number 1 and 2 only, because they believe that if the features in 1 and 2 are met, then the features or the characters in 3 and 4 will follow automatically. Okay, so now have a look at the features in 1 and 2. In 1 and 2 here, you get the word which I now put in the pink ink here, the word signature creation data. See, signature creation data in 1, and in number 2 you see also the word signature creation data. What is it? The signature creation data, I think that if you just look at this kind of signature, you will understand this very well. The signature creation data must be linked to the signatory only and with nobody else. That means that this thing is unique. And secondly, this thing, the signature creation data, must be what? Must be under the control of the signatory and of nobody else. That means that, well, it is unique and it is under the control of the signatory only. What is it? If we look at this kind of signature, the signature which is created with some biometrics features of a person, okay, we will understand that. Okay, we will understand the linkage with the signatory very well. Okay, if you use this kind of signature, if you use your fingerprint as your signature, is that linked to you only? Yes, because nobody else will have the same fingerprint as yours. Is that under your control? Yes, because you on your finger, nobody has your finger. So this thing, it is linked to you and it is under your own control. It is in your own control. It is in the sole control of yourself. Right. So what is the thing? Okay. This is the way the signature creation data. When you just place your fingerprint on the fingerprint reader, then the fingerprint reader will read your fingerprint and will send the data. Okay, so the data here, the data which are created from your fingerprint here, there are what? They are the signature creation data, and this data are linked to you only, and they were at the time of the creation of the signature, they were under your own control only. Nobody else had the control of it. Right. So it is well understood that in the case of a signature which is created by a biometric feature, it is this kind of signature which is known as a secure electronic signature. It is called a secure electronic signature because it is created by a method which is recognized by the industry as highly secure, so that the law will just presume that it is reliable without anyone having to prove, without you as a signatory having to prove at all. Right. So if we go back to the provision of Article 6.3 of the Australian Law on Electronic Signatures 2001, a signature which is created by a method which possesses a feature in 1, 2, 3, 4 here will be regarded by law as reliable. Okay, without anyone having to prove. Right. So this kind of signature, which is known as a secure electronic signature, includes the signature which is created by a biometric feature. Right. But in addition to this, the signature created by certain biometric features, it is understood that a secure e-signature also include a digital signature. Why do I say that the secure e-signatures also include digital signature? This is the conclusion, okay, drawn from the Guide to Enactment to the Australian Law on Electronic Signatures 2001. If you look at the Guide to Enactment, i.e. the explanation, okay, prepared by Australia, you will see that it has been explained that this kind of signature, the secure electronic signature, covers two types of signature. The first one is the signatures created by the use of a person biometric features, and the second one, it is the signature which is created by a PKI. Okay, the method. Remember the signature which is created by a PKI method. It is what? It is a so-called digital signature. So if anyone uses this kind of signature, then you will have the benefit of the legal presumption of reliability. You don't need to prove the reliability of your signature because the law already presumes that it is reliable. Okay, so now when we have seen section 6 here, article 6, when we have seen the significance and the meaning of article 6.3, right, of the model law on e-signatures 2001, now let's come to look at what is in our ETA, what is in Thailand's ETA. I should say that Thailand's ETA with respect to secure electronic signatures, is not different from the version, isn't different from the provision in the model law on electronic signature. If you look at our provision, it is contained in section 26. According to section 26, an electronic signature that meets the following features shall be deemed to be a reliable electronic signature 1, 2, 3, and 4. And if you look at the Thai wording, you will see that the Thai wording here, the wordings in the 1, 2, 3, 4 of section 26 of the Thai ETA mimic what you have seen from the 1, 2, 3, 4 in Article 6.3 of the Model Law on e-signature 2001. Okay, so my explanation of Article 6.3 of the Model Law of e-signatures 2001 will also apply to the Thailand's ETA in Article 26 as well. Okay, you're welcome to have a look at the wording, the full wording of Section 26 by yourself. All right. Now, when we have a clear picture of the legal presumption of reliability, okay, what is going to be explained, okay, as well is this: even though the law presumes that your signature is reliable, if your signature meets the features in 1, 2, 3, and 4 of section 26 or of Article 6.3 of the Model Law on e-commerce, right? Even though you will be regarded by law as the signatory, and the law will presume that your signature is reliable, you will also be allowed by law to repudiate your signature. Okay, let's suppose that you are now Bob. Oh, sorry, you are now Alice. You want to send a message to Bob, and your message now, okay, is affixed and e-signature, which is a digital signature. Of course, when a person uses a digital signature, that signature will be regarded by law as what? As reliable. Okay. In this case, a list will be detected as the signatory. Okay. So Bob can just presume that this message, the message from a list, is authentic, and the signature, which is affixed, which means the a list message, it is authentic as well, right? Even though the system used by Bob detects a list as the signatory, but a list can just repudiate it. A list can prove that no, okay, even though your computer detect me as the signatory, but I have not signed. I have not just sent this message. I have not just entered this signature. Okay, somebody else just did so. Okay, a list can say that, well, somebody else just stole my private key and just create this message. Somebody stole my private key to create this message, so that the message which appear to by my signature, it is not my signature. Somebody else just did so. Right. So in a way, a list here is now repudiating, this signature. Even though the law presume that it is authentic, it is a list signature. Okay, but a list can just present some evidence in repudiation of this signature. Okay, how can let's do so? If you look at Article 6.4 of the Model Law on e-signature 2001, you will see that Article 6.4 allows the signatory to just repudiate the signature, even though the signatory is detected as the signatory. The one who is believed to be the signatory can just repudiate that means that it is not his signature. Okay, so Article 6.4 say this. Paragraph 3 does not limit. I mean, the wording seems to be quite difficult to understand, okay? If you look at the wording here, you will find that it is quite difficult to understand, but I'm going to explain to you later. Article 6.4 provides as follows. Paragraph 3 does not limit, paragraph 3 is what? Paragraph 3, it is the provision which say that the signature which is created by a method which is of the descriptions in 1, 2, 3, 4 is regarded by law as reliable. Okay, even though we have paragraph 3 saying so, but paragraph 3 does not limit the ability of any person to adduce evidence of the non-reliability of an e-signature. This means that the meaning of this wording here, in fact, it is in the Article 6.4b. Okay, 6.4b allow the repudiation. What is meant by Article 6.4b is that even though the person who is detected as the signatory, okay, is so detected, that person can repudiate. That person can just produce or adduce evidence, okay, in order to show that that signature, it is not reliable, it is not his signature. Maybe even he can prove that that somebody else just stole his private key in order to create a message and in order to enter the signature, in order to affix the signature to that message. Okay, so if the person who is detected as the signatory does so, he is in a way repudiating that signature. He is doing so by adducing evidence of the non-reliability of the signature. Okay, so again, what is meant by Article 6.4b is that a person who is detected to be a signatory can just deny it. A person who is detected as the signatory can just repudiate it by proving, okay, by showing some evidence, okay, that in order to just show that it is not his signature, right? So when we look at the meaning, we are going to look at this repudiation provision in Thai law as well. Okay, what we have seen in Article 6.3b here, it is also found in the Thai version. In the Thai version, we see this in Section 26, Paragraph 2. The wording again seems to be very difficult, okay? But in order for us to understand the wording in paragraph 2 of Section 26, we will have to understand, the monologue on e-signatures first, because Section 26, okay, Section 26, Paragraph 1 and Paragraph 2 of the Thai ETA, it is from, Article 6 of the monologue on e-signature, okay? Maybe we are going to have a look at, Article 6.4 in full. Just now, I have given you the explanation that Paragraph 3, Article 6.4b allow the repudiation. Now, what about 6.4a? 6.4a is written also with the language which seems to be very, very difficult. Paragraph 3 does not limit the ability of any person to establish in any way for the purpose of satisfying the requirement referred to in Paragraph 1. Remember, Paragraph 1 is the requirement of reliability. That means that the meaning of Article 6.4a is this. Even though the law gives the legal presumption of reliability in the case where a person uses a signature which is of the descriptions in 1, 2, 3, 4 as listed by law, but nobody is forced to use that kind of signature, even though the law says that if you use a signature which is created by by special features in 1, 2, 3, 4, you are not in any way compelled by law to do so. You may just use any signature created by any other ways. But you just do not have the benefit of this legal presumption of reliability. If you use the signature created by any other method, you're welcome to do so, but you will not have the benefit of the legal presumption of reliability. That means that you will have to prove its reliability. Okay. But if you use the signature which is created by a method which possesses the features in 1, 2, 3, 4 as specified by law, then you don't need to prove the reliability because the law presumes that it is reliable. Okay, so again, Article 6(4) A and B, okay, just means this. First, in Article 6(4) A, this part means that even though the law says that you have the benefit of legal presumption, okay, in the case where you use the signature which fulfill the features in 1, 2, 3, 4 as specified by law, you don't need to do so. You don't need to, use that. You don't need to use the signature created by those special techniques. Okay, you're welcome to use the signature created by any other method, but you have to prove reliability by yourself. This is the meaning in Article 6(4) A. Now, the meaning of Article 6(4) B is that even though in the case where you use a signature created by special methods which possess feature in 1, 2, 3, 4 specified by law, and you therefore have the legal presumption of reliability, the law presumes that you are the signatory, and the law presumes that your message is authentic. You are welcome to adduce evidence, okay, that showing that signature is not yours. If you do so, you are just repudiating your signature. Okay, so this is meaning in Article 6(4) B. See, now in Thailand, we just implant this Article 6(4), okay, 4A and B of the Model Law on Electronic Signatures 2001 into our ETA. We put this concept in paragraph 2 of section 36, okay, with the following wording, okay. The provision of paragraph 1 does not imply any limitation that no other method exists for establishing the reliability of an e-signature, or does not limit the adducing of any evidence of the non-reliability of an electronic signature. So in a way, this just replicates what? This just mimic, okay, the Article 6(4) of the Model Law on e-signature 2001. Okay, so therefore my explanations on the Article 6(4) of the Model Law on e-signatures will also apply, okay, to also what you say in the section 26 paragraph 2 of the ETA of Thailand as well. Okay, now let me have a check on the screen again. Okay, we're going to make sure that everything is going on very, very well. Okay, now, okay, very good. Okay, I think that means that I do not receive your message telling me about any technical problems, so I shall understand that everything is going on very, very well. Okay, so now the second half of the lecture has been proceeded for about 50-something minutes. Okay, so I think that I'm going to give you the lecture for 10 more minutes, and then we are going to stop. Right? All right. Now perhaps we are going to spend about maybe 15 minutes. Okay, because what is next is to show you our decisions of the court. We in this country, in Thailand, Okay, we have indeed the ETA, of course, which is a product of replication from the Money Law on the Money Law on e-commerce 1996 and the Money Law on e-signatures 2001. Okay, and later we have also amended this ETA. We have in fact, we have in fact implanted in some provisions of the UN Convention on the use of e-communication in international contracts to classify into our ETA as well, so that we have new provisions of the ETA which have been inserted into the ETA. Okay, but before going to that, let me show you that after we have had the ETA for about 20 years, we to date have had a few decisions of the court. Okay, there are some decisions are decisions of the Supreme Court, some decisions are decisions of the Court of First Instance. Okay, we have some provisions of the courts, and I am in fact, I should just say that it is unfortunate that Thai courts do not seem to have proper understanding of the TETA. Maybe because the ETA seem to be very difficult in terms of the wording. Okay, the wording seems to be based upon some technicality, so that it is not the same thing as reading other pieces of this legislation. It is not the same thing as reading the courts of law in our country. It's like civil and commercial code, the penal code, something like that. Okay, it is not like reading the courts of law. It is the reading of what? It is the perusal of, the piece of this legislation which is founded on, on something very technical. Okay, so that the court find it very hard to understand the wording. Okay, so when the courts find it very hard to understand the wording, the court try to avoid the application of law. Normally, when the courts apply the law, okay, they will have to go through the requirements in the law, and they will have to apply the requirements in the law to the facts in the cases at hand, right? But what we will see shortly is that when courts, they apply the ETA, they did not apply requirements of the law as embodied in the ETA. The court seemed to just jump to the conclusion. Let's say that there is an issue as to whether or not the message sent by Facebook Messenger constitute writing or constitute written evidence. The court would have to go through the requirements with respect to writing or written evidence. Remember, we have talked about the status of data messages. In order for a data message to be recognized as writing or as written evidence, okay, a data message will have to fulfill the requirements set forth by law. Remember, the data message must be what? Must be accessible so as to be usable for subsequent reference, right? As we have dealt with in the previous lecture, when the court dealt with this kind of issue, the issue as to whether or not the message as sent via the Facebook Messenger, whether or not this kind of message was writing. According to the ETA, the court did not seem to apply the requirements in the law. The court just said, well, that was the writing, okay, without elaborating upon the reasons, okay, without going through the requirements set forth by the law. Why did the court do so? Why did the court decide the case without, applying requirements in the law? I presume that is because the court did not have proper understanding of what the law says, because what the law says seemed to be difficult for the court. What the law says what is worded in the ETA, it is something technical, it is something related to technicality, so that it is beyond the court understanding. Right? If the court understands what is meant by the law, the Thai ETA, the court will have to explore maybe the model law on e-commerce and the model law on e-signatures. The court will have to be well equipped with the English language proficiency. But when the court did not possess this kind of ability, the linguistic mastery, okay, the court did not understand what is meant by, let's say by section 8 of the Thai ETA or section 9 of the Thai ETA, so that when the court did not know what is wording was meant, the court just decided to just go to just approach this case by just jumping to the conclusion, okay, without going through the requirements set by the law. Okay, now we have for the papers, for our papers, I have brought to your attention, okay, two decisions of the court. In the first case, it is a decision of the Supreme Court. In the second case, it is also the decision of the Supreme Court as well. Okay, there are also decisions of the lower courts, i.e. the court of first instance, but I don't think that time permits me to just address all cases. Okay, so now let's have a look at the first case. The first case, it is a case concerned with the quick cash company. The second case is a case, okay, it is a case concerning the use of Facebook Messenger for transmission of messages. Okay, now let's have a look at the first case, the quick cash case. What is quick cash? Okay, quick cash, it is a company which provides loans for those who are, who are from what? From those who are from the grassroots families. Okay, the one who, for simply, the loans provided by quick cash are intended for those who are rather poor. Okay, so that this is a service for extending loan, personal loan to people of meager means of living. Okay, so that the quick cash company does this. Okay, they have the system under which people can just apply for loans from quick cash company. Okay, so in order to get a loan, a member of the quick cash company will have to use the ATM card given by this company. Okay, the ATM card given by quick cash. Okay, so the member of quick cash would have to just insert the card into the machine. Of course, it is the same way as using the ATM card for withdrawing money. Okay, but the thing is that the quick cash members did not have the money at their bank account. They would have to use the card in order to apply for the loans. Okay, they would have to insert the card into the ATM machine, right? And after that, they would have to just key their 4-digit PIN numbers. And after they just key, the 4-digit PIN number, they would be brought to the terminal or the system created by Quick Cash. Okay, the system would offer, the packages, loan packages. Okay, offering the loan ranging from 5,000 baht, 10,000 baht, 15,000 baht, up to 20,000 baht. This is the maximum limit. No more than this, because there seems to be a high rate of default. So that the Quick Cash company would have to also run the risk of defaults. They did not want to extend loans in an amount greater than this. And the Quick Cash also offer the repayment schemes ranging from 6 months up to 36 months. So the one member, that wanted to have a loan like this, that this member just use the ATM machine, use the ATM card to get a loan. that person just inserted the card into the machine and press the 4 digit. After that, that person just shows the loan package. After everything was selected, okay, and the loan was granted, the machine just dispensed money to that member. That member would have a slip, but the paper slip, the paper slip was, even though it was possessed by the the member, the borrower, okay, but Quick Cash did not have paper at all. Quick Cash would have just electronic messages on the system, okay. So when this member defaulted on payment, Quick Cash would have to sue the member. Quick Cash would have to sue the defaulting borrower. So now, in order to to initiate legal action against the borrower, then we would have to go to what the law said, okay? In this country, in Thailand, the law said that if you want to sue the borrower, you would have to have 2 things. First, written evidence. Secondly, signatures of the borrower, okay? On the part of Quick Cash company, they did not have any paper document. They only had data messages on their system, okay? So they would have to have written evidence in support of the contract, in support of the loan agreement, okay? So the question which arose is whether or not the message on the Quick Cash system was written evidence, and another issue was whether or not the message, electronic message stored on this Quick Cash system constitute a signature. The law required that this loan agreement be signed by the borrower. Whether or not we have to ask this question, okay? We have a question as to whether or not the electronic message which was stored on the Quick Cash company's system, okay, regarded by law as a signature of the borrower, okay? So in order to answer these questions, 2 questions, the question regarding written evidence and the question regarding the signature, we would have we would have to apply 2 provisions of law. With respect to the written evidence, we would have to apply Section 8 of the ETA. With respect to signature, we would have to apply Section 9 of the ETA. Remember. I show you again, the provision of Section 8. Remember, in order for a data message to be recognized as writing or written evidence, written evidence, okay, we will have to comply with the 2 requirements. Remember, the first requirement is that the data message must be accessible. The second one is that the message must be usable for subsequent reference. Right, but in this country, okay, we have also the third requirement. The message must be without any alteration in the meaning. In the money law on e-commerce, the money law on e-commerce has only 2 requirements, but the Thai ETA has three requirements, as we have dealt with in the previous lecture last week. Remember. So, in order for the court to decide whether or not the electronic messages as stored on the Quick Cash company's system, okay, whether or not they were regarded as writing or written evidence, the court would have to go through Section 8, and the court would have to check whether or not these 3 requirements were met. Correct? Right. This is the application of law. When you apply the law, you apply the law to the facts. You apply the requirements in the law to the facts concerned, the facts of the case concerned. Right. But if we look But if we look at what the court did, with respect to this case, okay, I'm showing you, the decision of the court. It was held that, okay, in this case, the quick cash company duly had written evidence and also any signature of the borrower. Well, the answers, the decisions of the courts were not wrong, they were right. But the thing is that the court just failed to go through the provision of law. The court just failed to go through the requirements set forth by the law. So that the decisions, the judgment arrived at by the court did not seem to provide sort of the reasonable authority, because the court did not give the reasoning. Okay, the court did not go through the requirements set forth by the law. The court did not, in a way, apply the law to the facts. Okay, what was said by the court is this. The court said, well, the facts reveal that the defendant, that is the borrower here, okay? The facts reveal that the defendant voluntarily borrowed money from the plaintiff on the terms and conditions fixed by the plaintiff. It was a civil and commercial transaction made by the use of data messages under the ETA, fine. And then the court went on to say this: given that the defendant used a cash dispenser card and entered personal identification numbers as if they were his own signature for withdrawing money as required by the defendant, and then press a button to confirm the transaction and to cash, as well as an accompanying slip. Such conduct amounted to evidence of the loan from the plaintiff. Such conduct amounted to evidence. The court just tends to mean written evidence. Such conduct amounted to written evidence of the loan from the plaintiff. Okay. Put simply, the court said that, well, we can find written evidence in support of the loan agreement made between the defendant and the plaintiff. We could now find written evidence in support of this loan agreement. Okay, the written evidence here, it was a paper, but it was an electronic record stored on the quick cash company's system, right? So in fact, what the court should have done is what? Is going through the provision of Section 8. Okay, the court should have just applied the law in the way that the court would have to go through all the requirements set forth in Section 8. The requirement of accessibility, the requirement of usability for subsequent reference. Remember, there are 3 requirements in the Thai ETA: 1, 2, and 3. The first one is the requirement that the data message be accessible. The second one is the requirement that the data message be usable for subsequent reference. And the third one is the requirement that the data message be without any alteration in the meaning. Okay, so the Supreme Court of Thailand should have applied the law by going through its requirement required by Section 8. But what the court did in its decision, okay, is just jumping to an immediate conclusion that in this case the quick cash company already had written evidence. The court did not give the reason why so. This reveals what? This reveals the court's lack of understanding of Section 8. As I have mentioned, okay, this section is worded. This section has been framed, okay, on the basis of the monologue on e-commerce. Okay, so that when the wording seemed to be very difficult to understand, the court chose not to look at it. The court did not just go through the details of it, the court just jumped to the conclusion, okay, and just said that, well, in this case, the message in the company, in the company's database or the company's system constitute written evidence according to Section 8, right? So that now we are going to go through one more decisions of the court, okay? The second decision, it is the decisions regarding the transmission of messages through Facebook Messenger. I hope that everybody in here knows, okay, the functionality of the Facebook Messengers, okay? Now let me again check what's going on in on the screen now, okay? Nobody just sent me messages telling me, informing me of any technical problems. Okay, so I should again presume that everything is going on very, very well. Okay, good. Time seems to fly actually. Okay, so now the second half of the lecture has been for more than 1 hour now. Okay, I'm going to stop my lecture today in just a few minutes. Okay, now coming to the second case, which has been brought before the Supreme Court. Okay. This case just came about in just 2017, which is not too long. This is in fact a very recent case. Okay, so it was again concerned with the loan. The thing is that A and B, let's say A and B, they made a loan agreement. Okay, A borrowed money from B. When A borrowed money from B, A did not return the money in full. Okay, something like in the 600,000 something baht remains unpaid. Okay, so this amount, 670,000 baht, remain unpaid, so that the lender seemed to be very upset. So the lender just demanded repayment from the borrower so many times, but to no avail. Okay, so that the lender seemed to be upset, and the lender just wanted to discharge the borrower from this debt. Right. The lender said, well, now the borrower, I am so upset. I'm going to discharge you from this debt, so that you will no longer be indebted to me. Right. So, what is going to important is this in Thai law. Thai law, in fact, this is what is embodied in Section 340 of the Civil and Commercial Code of Thailand. Okay, according to Section 340, if the obligation is evidenced by writing, a discharge of the obligation shall be made in writing as well. That means that, okay, in this case, when A borrowed money from B, okay, the loan agreement between A and B was evidence in writing. Okay, so when the contract was supported by written evidence, the law required that a discharge of this debt would have to be made in writing as well. Okay, so when B, the lender, in this case B is the lender, when the lender, okay, declares an intention to discharge A from this debt, the lender did not do so by writing on a piece of paper. The lender just sent messages via the Facebook Messenger. Okay, when the lender sent messages by Facebook Messenger, okay, we therefore did not have any paper document. We had data messages. So the question which arose is just that. Okay, the question was this: were messages transmitted via Facebook Messenger like this? Okay, written evidence or writing, in order for the discharge of this debt to be enforceable or to be recognized by law, where the law requires that the discharge of this debt be made in writing. Okay, did we have any writing in this case? did the messages which were transmitted via Facebook Messenger, okay, the constitute writing for the purpose of the discharge of this debt, right? In this case, the court just render judgment this way. The court said, well, okay, with respect to the messages transmitted by the plaintiff, with respect to the messages transmitted by the plaintiff to the defendant via Facebook, although they did not bear the plaintiff's signature, okay, the name of the sender also appeared in the plaintiff's transmission, and the plaintiff also admitted that the plaintiff had actually transmitted the messages to the defendant. The conversation messages are therefore regarded as being the declaration of an intention to discharge the defendants from the obligation in writing under Section 340 of the Civil and Commercial Code. So put simply, the conclusion of the court is that messages which were transmitted via Facebook Messenger, okay, constitute writing in the eyes of the law, okay, according to the ETA. But the thing is that the court just rendered the judgment without going through the requirements in Section 8 at all. If the court, render judgment to the effect of concluding that messages sent via Facebook Messenger, okay, were writing, then the court would have to go through Section 8. The court would have to apply the requirement in Section 8 to the facts. In this case, the court should have said that, well, the messages sent via Facebook Messenger, okay, they were accessible, they were, accessible, they were usable for subsequent reference without its meaning being altered. Fine, if the court did so. But the thing is that the court did not do so. The court did not go through the requirements, okay, that's specified by law. The court just immediately jumped to the conclusion that messages sent through Facebook Messenger were writing, okay, in the eyes of the law, according to, Section 340 and also Section 340 of the CCC of the Civil and Commercial Code, and according to Section 8 of the ETA, without elaboration upon the minimum requirements specified by Section 8 of the ETA at all. Okay, so we have seen from this case that in this country, okay, that it seems that people lack proper understanding of the ETA. Okay, when I say people, this also include the judiciary, the courts, of course. Okay, the lack of understanding or insufficient understanding of the ETA. It is, I think that it is simple. Okay, it is simply based on the fact that this act seems to be worded with a lot of technicality. Okay, you will have to understand some technicality before understand the wording of the act. And of course, this act also, it is a product from replication of the model law on e-commerce and model law on electronic signatures. Also, the replication, okay, in some provisions, okay, the replications from the UN Convention on the e-communication, on the use of e-communication in international contracts, so that if you do not, okay, explore, those instruments by UN, then you will not be able to understand Thai ETA. So now, time is right for you to create your proper understanding of the ETA. I do not want the court, to decide this case in this way anymore. Okay, otherwise the judgment or the decisions of the court will not be, the reasonable authority for other courts. Okay, so that's it for today. I think that we have spent about more than 2 hours today. Okay, so that I think that I stop here and I'm going to continue the lecture from this point next time. Okay, we will have a look at some more provision regarding original, provision regarding regarding the retention of data messages. Okay, and some other provisions, okay, that will require about maybe 2 or 3 hours. Okay, so that let's defer our discussion to next Friday. Thank you very much for your attention today, and again, see you next Friday next week. Thank you. Have a good weekend. Okay, bye bye.